Hello and welcome to See You in Court, a podcast that informs you about the Georgia civil justice system, what it means to you, and how it protects individual rights. During each episode, we dive deep into stories, cases, and insights that matter to Georgians. You can learn more on our website at www.seeyouincourtpodcast.org. Join the conversation on our YouTube channel at See You in Court Podcast, and stay connected with us on our Facebook page at facebook.com/seeyouincourtpodcast. This podcast is sponsored by the Georgia Civil Justice Foundation. Your hosts are Robin Fraser Clark and Lester Tate, who are both past presidents of the State Bar of Georgia and who both serve on the board of directors of the Georgia Civil Justice Foundation. And now this episode of See You in Court.
Good morning, friends and lovers of the law, and welcome to See You in Court. I am Robin Fraser Clark, and with us here today is our super co-host, the
indescribable.
The amazing Lester Tate.
Yeah.
Lester, how you doing this morning?
I'm doing great. You're as always too kind. But it's always a great day to do a See You in Court podcast, and we've got a great guest today, and I'm looking forward to it.
Yeah, maybe he's going to give you a little grief about Georgia Tech or something like that.
Well, that my Yellow Jackets are in the NCAA baseball tournament. They got to go over there, play in Athens. So we got a little tournament style, clean old fashioned hate going here.
That'll be good. That'll be a good game. We love going over to watch a little baseball over in Athens. It's fun. Well, today, listeners, we're just thrilled to have an incredible person join us as our guest, the Honorable Alvin Wong, Judge of the DeKalb County State Court. And let me introduce our listeners to Judge Wong. While visiting an uncle in Richmond, Virginia with his family, when Judge Wong was 14, his father enrolled him at Fishburne Military Academy in Waynesboro, Virginia, shook his hand, and said he'd see him next summer. He followed a classmate from Fishburne to Auburn University without even knowing where it was. He graduated early and moved to Atlanta. He started taking night classes at John Marshall Law School and passed the Georgia Bar in 1976. He hung out a shingle and worked as a trial lawyer, and then was a partner at Gambrell and Stoltz, which is now Baker Donaldson, for 20 years. Judge Wong was elected to the State Court of DeKalb County in 1999. And since his election in 1999, he's been reelected unopposed to 6 consecutive terms. With his election in 1999, he became the first Asian American judge in Georgia history. At that time, Asians made up less than 2% of registered voters in DeKalb County. In 2004, Judge Wong co-founded a DUI court to help people, calling it one of the most rewarding things he's done. He also sits on the board of the Lifeline Animal Project, a nonprofit that helps turn Atlanta animal shelters into no-kill shelters. He also brings to the courthouse Coco, a Dachshund Chihuahua mix he rescued a decade ago. Jurors love to meet her after a trial is over. Judge Wong was elected by his peers in 2021 as president of the Georgia Council of State Court Judges, overseeing the entire state. His election marked the first time an Asian American served as president of any judicial council in Georgia. In 1993, Judge Wong and Professor Natsu Sato of Georgia State University Law School combed the state bar directory to find 10 attorneys to start an Asian American Bar Association. Today, the Georgia Asian Pacific Bar Association, GAPABA, G-A-P-A-B-A, we call it GAPABA, has 750 members. In 2014, GAPABA named its top prize the Judge Alvin T. Wong Pioneer Award. It is given in his honor to a lawyer who demonstrates leadership to pave the way for the advancement of APA attorneys. He is the recipient of the 2017 Traditions of Excellence Award, presented by the General Practice and Trial Section of the State Bar of Georgia. He received the 2022 Randolph Thrower Lifetime Achievement Award presented by the Committee to Promote Inclusion in the Profession of the State Bar of Georgia. Judge Wong serves the ABA Standing Committee on Ethics and Professional Responsibility, Judges Advisory Committee, and as a Fernbank Museum of Natural History trustee and the National Asian Bar NAPABA Law Foundation board member, mentoring future leaders as co-director of its Thomas Tang National Moot Court Competition. I could go on, but we'd be here all day about the accolades about Judge Wong. He is an amazing person. Judge Wong, thank you and welcome to the show.
Thank you so much. Look forward to our talk.
Yeah,
we, if you were watching on YouTube instead of just listening, you would have got to see Coco as well. So we need to welcome Coco to the podcast as well.
Yeah, Coco's getting a little on in age. She's almost 15, but she mobility has become a problem. But she still barks and eats and poops. So we're going to keep her around as long as we can.
We often see when we're outside the courthouse, see you walking Coco at lunch breaks and afternoon breaks. So it's fun to see you take her out.
Thanks.
Judge Wong, I gave our listeners a little bit about your background, but I've heard you tell your story of how you came to America and your studies here. And I may have glossed over some things because you have a very rich story. Can you tell the listeners some inside scoop about your journey and your story here in America?
Sure. Thanks. I grew up in actually a pretty well-to-do kind of family in Hong Kong. My dad was a businessman. She was in the advertising business, and later on in life, he was in the import and export business, so he did well. He came to this country in 1939 to go to college, and then World War II broke out, and he had no communication, no resources from home, from China. He came from Shanghai. So I think he was 25, 26. He was in Boston area, and he just joined the Marines. He went to boot camp at Parris Island and was a boot in the Marines for the duration of the war. He served, I think, a little bit more than a year. And as part of that process, he became a United States citizen. And as we were born as U.S. citizens, which, as you understand the immigration process, it's a huge, huge deal. And my brother and I had two siblings. I have a younger brother. I have a younger sister. My brother and I were a year apart. And, we were well-behaved children. So my mother decided that these boys are not going to make anything of themselves unless they get out of here. And so we were visiting that summer. My dad was working for an outfit in Chicago. He took his family on a business trip. And we're visiting uncle, this and that. We're driving around, and there's all these military schools in the foothills of the Blue Ridge in Virginia, in Waynesboro and Stanton. So we ended up at the end of the summer, my dad sent my brother up the road to a place called Stanton Military Academy, and I went to Fishburne Military School in Waynesboro. And I think they did that on purpose because they didn't want us to be in the shadow of each other. So I went to one place, he went to one place, and we were about 25 miles apart. And he dropped me off, shook hands, says, "Do well, son. I'll see you next summer." And there I am, 14 years old, standing there, said, wow. It was all mashed potato. There's no rice in this place.
Judge Wong, when I think about kids today, I don't know many 14-year-olds who could handle that kind of.
Well,
I just don't know many who could handle that.
It wasn't a choice,
Yeah.
And I think that has made a huge impression on the way I am or the way I operate and so on. It's a very early on in life, the kind of lesson that you have to do what you got to do. And I think that is a lesson that we don't see too many of in young people today.
I totally agree. And as I've told you before, that, in my opinion, that changed the trajectory of your life.
It did.
Um,
It really
and
did.
we are the better for it. I don't know that your dad
Wow.
planned on so many friendships here in DeKalb County as a result, but
Well, thank you.
we're very selfishly glad your dad dropped you off at Fishburne Academy.
Thank you.
Tell us a little bit about your career as a lawyer. You went to night law school, which was hard because you're working during the day. I mean,
I was.
law school's hard enough, but to do it while you're working full time, really hard. Why did you decide to go to law school? Why did you want to be a lawyer?
Well, I give credit to two teachers that I had in high school. My U.S. history teacher, Gene Shepard, in the 10th grade, and Jim Pittman in my government class in my senior year in high school at Fishburne. I just was fascinated with the judicial process, the governmental legislative process. And I said, boy, I just always had it in the back of my mind that I was going to go to law school. But I got to Auburn. I got through school. I did okay. I wasn't a great student. I don't know why I was in such a hurry. I said, I need to get out of here. So I was always in a hurry. And that's part of my trade too, I guess. So I moved up here to Atlanta and I started working. I was an insurance underwriter at Allstate. That was my first job. That's how I got to Atlanta. I took a job up here, moved up here, went to work, and then probably about 3 or 4 months into my first working experience, and one day I walked in. My supervisor looked at me and says, "Well, you're supposed, I'm talking to somebody, it says 8:17, and you're supposed to be at your desk working at 8:15. And I said, well, I'm not sure this is the life for me. So I started looking around and then found these night law schools and made some inquiries. And I said, boy, I can afford to do this. Working, I got the money. I cannot go and pay $15,000, $20,000, $30,000, $40,000 for tuition. It's just not in my means. But a night law school, I can afford that. So I enrolled in the spring of 1974 and started law school at night and worked during the day and just hustled up and got through school, passed the bar, and started practicing law.
So have you been did you go back to Hong Kong? Do you go back now? I know when it was under British rule and I guess British judicial system.
Yeah, I never understood the Asians wearing wigs. White wigs.
Right.
I've been back, when I was in college and when I would go, in high school, those summers I was fortunate enough to go and still have good friends there. My sister still lives in Hong Kong, but I have not been to Hong Kong since 2007. That's the last time I went. I'm now I go home, they look at me and say, this guy's a tourist. And so, but I still have friends there. I still have family there.
When you first started out, you passed the bar, you finished law school, you passed the bar, you're talking about hustling. Tell us a little bit about that. How did you hustle to get cases, to represent clients? What did you do?
When I took the bar exam, I took the early bar. Back then you can do that in February. I took the bar. I was waiting for bar results. I was to graduate in June. My best friend was Duncan Wheel, who was a Superior Court, who later became a Superior Court judge in Richmond County down in Augusta. So he and I were study buddies, and he got a job working for Edgar Neely. And I took the job. I went out and I said, I need a clerkship. I need to do something. So I made up a list of about 5-10 lawyers. And the top of my list was a guy named Hugh Head. I don't know if you remember Mr. Head, but Mr. Head did plaintiff's work. He was a medical malpractice lawyer, so practitioner. So I went into his office. I got dressed up one morning, Monday morning, I put on a suit, and I went into his office and I said, "I'd like to see Mr. Head." I didn't have an appointment. I didn't have anything. I just said, "I'd like to see Mr. Head." Long story short, I waited till about 3 o'clock that afternoon. I wouldn't leave. I just would not leave until he talked to me. And I was a pain. And he finally brought me into the office. And, you know, the good Lord takes care of idiots and children. About this time, the phone rings. His crony from GTLA or ATLA board from Maryland had a niece that got arrested overnight in Atlanta in a car accident, had some drugs and so on. So he doesn't know anything about criminal law. I'm sitting in his office, this phone ring, and he points to the phone. I pick up the extension, and they finished their conversation. He looked at me and said, "What do you think?" So I gave him my best criminal procedure pitch, at the end of which he looked at me, he reached in his pocket, pulled out a bill roll, I mean a literal roll of $100 bills in a rubber band, peeled out 2 of them. He opened his drawer and he threw a key across the desk and said, "I'll see you at 9 o'clock in the morning." That's how I got my first job.
And how long did you stay there with him?
I stayed there. That was in February. I passed the bar on June 11th. I tried my first case with him about 6 weeks after that. And then in September, he called me in the day before my 25th birthday. 76. Either I was 25 or 26. It was the day before my birthday. He said, "Bring me your books, bring me your keys, bring me the checkbooks, and all of that." And we go through the file. He writes me a $5,000 check. You know, back in those days, that's a lot of money. He wrote a check for $5,000. He said, "Let me have your key." And I said, "Sir," he says, "I think you're going to be fine, but you got to go see if you can do it on your own. So let me have your key. Good luck."
Wow.
So I was shoved out the door. And I'm walking down the street on Peachtree, just not knowing what had hit me. And my birthday is the next day. I got a bunch of cash in my pocket, but I got nowhere to go. So I ran into a guy named a professor of mine, lawyer, still practicing, Barry Weiner. He's out in Sandy Springs Circle now. So I ran into him, and he was teaching like an ethics course as a ProHag professor at John Marshall. And we were just chatting, and he says, "Well, I got a little office in my office in Colony Square. I'll rent it to you for $100 a month." I said, "Okay." I paid $100 a month, hooked up a phone, printed some stationery, bought a fancy Selectric typewriter. I was in business. And I would go to the jail, at Fulton County Jail at Rice Street. Back in those days, Monday morning, if you show up at 6 o'clock, they'll feed you breakfast, you sign the list, and judge comes on the bench at 6:30 and make appointments on these criminal cases. They pay back then $25 a case for misdemeanor, $50 a case for a felony, not an hour, a case. If you took the assignment, you're it. But if you showed up, you get on top of that sheet, you get 2 or 3 turns, pay rent for the month. That's how I started.
You know, I as much as I am supportive of having a public defender system that, you know, has, you know, training and, you know, dedicates folks to do that. When I started out, you know, still you would go sit in the jury box, you know, and the judge would appoint you. We got a little more than $50 a case, but it you know, it still wasn't a lot. But, you know, I got so much experience doing that I think younger lawyers now, you know, are sort of missing out on, you know, and you didn't have to go be a public defender or a prosecutor, you know, to try try a lot of cases. Was that your experience as well?
Oh, yes. And, when you do that, not only do you get exposure in the courtroom, you just get exposure to people, judges, clerks, and so on. So I went down there, and as part of that process, I would go to the courthouses and just walk into the judge's chamber, just like I did with Mr. Head, and said, I'm a new lawyer looking for work and appreciate the judge's consideration. So I did that one morning, walked into Charlie Weltner's office. Judge Weltner then was a Superior Court judge. He had to come off Congress. He was big buddies with White Fowler, who was the president of the city council. So one morning I walked in, and there's Weltner and White Fowler. They're yucking it up in that reception area. And I walked in, and I'm, handing them a card and this and that, and I leave. About a month later, the secretary calls up, Ms. Barber called up and said, Judge wants to see you. So I go up there, and he appoints me to a criminal case, a felony possession with intent to distribute case. I was co-counsel. There's a conflict. Billy Sprue was representing the other defendant. So the judge says, well, this case is not going to get settled or get pled out, but so get ready. So I tried felony case with Billy as co-counsel. I lost. My client went to jail, and I learned a lot. So, within 6 months of passing the bar, I've tried a civil jury case. I've tried a felony jury case. So, it was experience that you can't find those. It just circumstance. It gave me the opportunity. So I've always been grateful, particularly to Judge Weltner, who took me under his wings and taught me stuff. He was a great mentor.
I think the opportunities to do that sort of interaction with folks in the courtroom, even, clerks, secretaries, law clerks, judges, I don't think we get enough of that anymore. I hate to sound old, but back in the day, you could walk in and talk to a judge. We don't have that very, very much anymore. I regret that, but
and I particularly enjoyed lawyers that are willing to take young ones under their wings. My good friend Doug Smith at Carlock Copeland, when he was still practicing over there, I offered to him and said, "Well, you bring all your associates, come," and I said, "If you got one that wants to try a misdemeanor criminal case, send them to me." So I partnered him up with Max. He sent me one, and I partnered him up with Max Hirsch over here in Decatur, a great criminal defense lawyer. I said, "Max, can you be this guy's coach, please, and just watch him and help him?" And they came in, got a not guilty verdict on a public indecency case, which was great. And, the quid pro quo for Max was, now all the big firms, they got criminal matters, they call him. So it was good for him, and it was good for the young associate. I wish we had more opportunities like that. But nowadays, though, I just don't think we try cases like we used to. Or we don't try as many of them as we used to.
Yeah. Let's talk a little bit about that.
Yes, ma'am.
In your experience, how has that changed? Everyone says we're not trying as many. Lester tries a lot because he does everything.
Well, Lester tries everything because nobody
tries
else
everything.
Have the nerve to go try them.
But, Lester and I both have tried 100 cases. Lester's tried more than 100 cases. I've tried 100. It is rare, Judge, you probably know this, for any lawyer now to say, I've tried 100 cases. That's very rare. And even like for ABOTA membership, American Board of Trial Advocates, they've had to lower their threshold of number of trials to be able to get new members.
They took it from 25 to 10, and now it's probably going to go down to about 7, just because they can't sustain the membership, which is sad, but it's a fact of modern day life, I guess.
Well, I think one of the complicated factor is cases are more complex. There's a lot more science involved, at least in the civil arena of the kind of cases y'all do, the tort cases, the injury cases. It's a lot more sophisticated. The science has made it more sophisticated. And discovery process has made it more complicated. So in order to take a case from beginning to end, it's a lot of work to get it there. It's a lot of resources to get it there. And usually when you get it there, the stakes are so high that folks both sides are a little leery of putting it up for a trial. So we just don't try as many cases on the civil side, but on the criminal side, I'm in my world, in the misdemeanor world, most of those are cases that should be resolved, and with pleas and whatnot, and a lot of that depends on the personality of the judge. In my world. So, what I do is half of them don't come. I don't try any criminal cases. I haven't tried a criminal case probably in 6 months. I've got big calendars, but I resolve them. And felony court, no, but you take a look at a case like the YSL trial that's going on down in Fulton in front of Judge Glanville.
Sure.
They've been in court for over a year in that case. I've got 3 or 4 defense lawyers that's stuck in that case, and I have to put criminal cases over and over because there's conflict. There's nothing I can do about it.
Mm-hmm.
So I think there's just a lot of factors: the load, the complication, the complexity, and so on. We just don't try as many cases.
Yeah. Judge, you, in my opinion, are probably one of the judges who have the most experience as a lawyer. We have a lot of judges now that, as Lester and I like to say, has he ever struck a jury? That always bothers us if a trial judge has never struck a jury and they're presiding over our case. But like you've actually struck many juries as a lawyer. Represented. We also talk about. Have you ever represented a real live person sitting across the table from you? That's one of our little standards. Also, you bring that experience to the bench, unlike many judges. So I know I've observed it, but tell me how you think that actual on the ground, feet on the ground experience has helped you become a judge or informed your work as a judge.
I think that kind of experience let you see the unstated problems in a case the lawyers has. Difficulty with a client, difficulty with evidence, difficulty with scheduling, all of those things that unless you've been a lawyer in a courtroom, you got to be in the shoes in order to understand. I can't get somebody here, and the judge is giving me a hard time by having a witness on the stand by 1 o'clock. I can't get them here till 3 o'clock. That kind of issue. So I think as a judge with that sort of experience and having been there, you anticipate and you try to create a situation where you don't have those kind of problems. And when you don't have those kind of problems, your case gets tried and it gets done. Great example, since COVID, we are buried in cases, especially Superior Court or the serious felonies. So on certain days, I can't get jurors. Forget Mondays, sometime Tuesdays. Superior Court has priority and they grab up all the jurors for these felony trials. So what do? So now I've implemented, and it's worked beautifully, on a med-mal case, for example, or a case that takes a week or more. I pick a jury on the Thursday before. I start evidence on the following Monday. It gives folks time to get their ducks in a row. I can take care of any pretrial matters without inconveniencing jury. We start on Monday morning. We get it done by Friday.
Yeah, I like that.
So one of my favorite quotes after Lewis Powell got appointed to the Supreme Court, he'd never been a judge anywhere. He'd been president of the ABA. He'd been chairman of the Virginia School Board. But he was a big Redskins fan, now the Commanders, but then the Redskins. And he had Larry Brown, the running back from the Redskins, in his chambers for lunch one day. And Larry Brown says, Judge, Justice, you must just love this. And he goes, no, Larry said, actually, I hate it. And he said, why would you hate it? And he said, Larry, would you rather play or referee? And so that was his take on becoming a judge. And, we have a lot of people now that go on the bench early. They really hadn't, their career hadn't been mature, but you had a very mature career before you did this. So, what motivated you to want you to go on the bench? And, is it more fun to play or to referee?
I've sort of, in my younger days, running around the courthouses and seeing all these people with white hair sitting up there and making pronouncements, making decisions. I said, gee, that sure looks like fun. I would love to do that one day. So I've always aspired to be a judge very early on. And when I had the opportunity, I ran and got elected, got on the bench. My good friend and mentor, Kent Lawrence, who, by the way, was a big bulldog. He was a star running back in the 60s. He was the chief judge in Athens. And, we go to these council meetings, and he looked at me one day and he says, Wong, you're going to learn that it's going to take you about 5 years to figure out you need to keep your mouth shut. So you're right about refereeing. And it's now, well into my career as a judge, I really have enjoyed it very much, I would have to say, because it's people say in the courtroom, it's a pyramid. The judge has all the power on top and everybody's like down like a pyramid. No, I say that's not true. It's more of a concentric circle, 3 of them. The power base moves around the courtroom depending on what's going on. And the judge's role, I think, is to be the chess master. You want to move these pieces so that you can get the work done, get the trial done. 2 things I think a judge has to do: start a trial, which means picking the jury, and end the trial, which means charging the jury. Everything in between is totally forensic. Everybody's got different styles, different ways of doing things. None of that. You got to put that jury in the box, make sure you get the law right at the end. That's the role of the judge. And I've enjoyed it very much.
Judge Wong, I think what many of us trial lawyers would say about you is that you have a unique ability to evaluate claims, to evaluate cases. I believe that because you've had that experience as a lawyer before you took the bench. But you are well known for being able to help resolve cases before a verdict, before even getting to a point of having to strike a jury. So tell us about that. Some judges would officially call it, judicially hosted mediation, but you have your own way of going about it. Can you tell us a little bit about how that evolved?
Well, when Judge, remember Judge Etheridge down in Fulton County, he had he was the first sort of the Superior Court judge down there that did this judicial hosted mediation or settlement conference. So it's basically a mediation with the court. So I'm sort of copied. I said, well, I think I have a pretty good friendly personality. I can talk to most people, like people, and I don't have a problem with talking to people. So I started doing that, copying that model, and it sort of evolved to the point where most of the time I don't need the parties. So, in my experience has been when people sit down and recount what happened, who's right, who's wrong, it doesn't lend itself to resolution. So pretty soon I said, well, there's really no need to have the parties here unless the lawyer tells me I don't have control of my plaintiff, or my adjuster needs to hear this, or the defendant needs to hear this. So pretty soon I figure out the ones that don't need to be there, I don't need them. Then the next thing I figured out is that, well, if I meet with these people, there's no reason I couldn't talk to them on the phone. So I get permission from both sides that I can have ex parte conversation about settlement, and I get them on the phone. And it's amazing how a little conversation can lend to results. In the old days, the lawyers would get together with each other and talk about settling the case and settle a case. Now, we don't seem to be able to do that. We need mediation. We need a neutral, we need a independent person in order for us to make a decision. I guess it's a lot of times it's because the client seems to have trouble with what you're telling them, or they believe what the other side is telling them, and so on and so forth. So now the way I do it is, first thing I do is, hey, y'all want me to take a shot? Have you been to mediation? You couldn't settle it. Where were you? How far apart are you? Would you like for me to try to help you? And most of the time, they say, yeah, give it a shot. So, well, can I talk to y'all on the phone independently? And the rule is, I'm not going to get off the case because we're going to jury try it anyway, so it doesn't matter. And so you go get permission from your client or your carrier and whoever, and give you permission to do that, and we'll do it. And I've had a huge amount of success in resolving cases. Really.
Do you believe, I had a professor in law school that once said that whenever a case goes to trial, it means that one side has misevaluated the case, because if everybody's evaluated it correctly, it ought to resolve. And I tried a case a couple of weeks ago where I think they had offered 200 and we had demanded 825, and it came in at 790, which was right. It was within the brackets of what the last offer demand was. It was closer to what we had put out there, but it made me think of that concept. And I'm curious, because you've tried so many cases and settled so many cases. Do you think there's some truth in that?
Yes. There's two sides to every coin. Okay, everybody see things a little differently. And I think the kind of cases that gets tried are not the good cases, because the good cases settle. It's not the bad cases, because the bad cases settle. It's the kind of case. Okay? It's you can hit big or you can lose big kind of case. And everybody have like very different expectation of how they come out. And those are the cases that usually gets tried. A lot of stakes, a lot at stake. And, I'm usually pretty good about guessing how it's going to come out. But in the last 2 or 3 that I've done, I wasn't anywhere near close. I was totally wrong. And in one case, I keep browbeating both sides during the trial. Don't you all want to talk? Don't you all want to talk? And some of them come back and say we have high lows. Some of them have high lows before they even get started that I don't know about or they didn't tell me. But usually the ones that get trials, like Charlie says, that they're just different expectations. Not that it's bad or good. It's just both sides expect different results. And then they'll tell you, I've mock trial this. We've had what do you call those?
His groups.
Focus
groups and all of that. And, we had results that turn out this, turn out that. Well, sometimes it's true, sometimes it's not.
Well, I'll say, you have amazed me throughout the years with your ability to put a number on a case. And there was one time when, not a case you had anything to do with, but you and I were talking about a case that wrongful death, but it had severe issues about whether a personal liability umbrella policy would apply and whether there's any liability. Could I win on appeal? I mean, it just was fraught with legal issues. And there was a very large personal liability umbrella policy, but you told me, you said, yeah, but you would take, and you named a number. And I said, yeah, if they offered that, I'd take that. And I'll be darned if we didn't settle that at mediation for the number you said. And I'll never forget it because, like, God, Judge Wong nailed it. He picked that number months ago, and it just amazed me. And so if you ever tell me a number, Judge Wong, I'm likely to go with that number. I'm just going to tell you.
Well, yeah, that's good to know.
Yeah. Let's talk a little bit, Judge, about what you've seen in your experience, your career in DeKalb with jurors. And how has the juror makeup in DeKalb County changed based on what you're seeing?
I don't think our jury makeup has changed all that much. We have a very, very diverse county. We draw jurors from both ends of the county. And the law makes it that you have to have the balance and gender, age, race, and so on. So we have a very, very diverse pool of jurors. I think we have very smart jurors, despite education level. And I find most jurors are very attentive once they are in the box. So that I don't think has changed all that much. In fact, I think jurors, especially on these medical cases and products cases with a lot of science, they're very attentive, very smart, which is a good thing.
Usually get it right.
They usually get it right.
Yeah. What would you tell? So we hope we have a lot of non-lawyers listening as well. What would you tell citizens about jury duty? You hear about people saying, "Oh, got a summons to be a juror," and they just dread it. They try to get out of it, do anything to get out. What I have found is once they're on a jury, jurors will tell me after a trial that was one of the most rewarding experiences they've ever had.
What I say, and I say this to every jury panel, all the jury panels that come into the courtroom when we do jury selection, my standard pitch to all the jurors is this: said, we do not have a justice system until you come in here, and you came in here to do this. Because without you, we don't have a justice system. That's it. That's the bottom line. You're not here for the money. We're asking you for a lot of personal sacrifice. We understand that, but you as a citizen, this is your obligation. And if you do this and nothing else in your civic life, you're good with me. And so, and I want to thank everybody in advance for taking the time and being here. And usually most folks are, like you said, Rob, many of them have said, I want to be a juror. I want to have that experience. And I debrief every jury after I try a case. I go in the court, I go in the jury room, I talk to them, and everybody seems to be, and say, oh boy, we're glad we're not in the 6-week trial, but this was fun. And when you have tough cases where they deliberate for more than a day or a few hours, and they come back and they all beat up and they're all emotionally drained, and they say, wow, boy, I didn't realize this and that. So I think generally folks are pretty receptive to be on the jury. They don't want to be there. I don't blame them.
But once they are there, they enjoy it, seems like.
Yes, they take their job serious.
Yeah.
So what makes a great trial lawyer?
I think a great trial lawyer understands what the problem in his or her case is. We have so many that just sort of put the blinders on. If it's a liability problem, they're going to focus on trying damages, or vice versa. I think the great trial lawyer understands where the pitfalls are and how to get around them, or how to admit to them, how to deal with them, and own up to them, and understand that it is a problem for their case. The ability to read people. There's a lot of lawyers that come in the courtroom, they want to talk. It's all blah, 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 blah. Tommy Malone and Judge Graves gave a great seminar on jury selection. Judge Graves says, when I pick a jury, I'm going to sit down and I'm going to let the other side do all the work. I'm going to sit there and watch and listen. Now, you all know, both of you try plenty of cases. After about 30 minutes of jury selection, you know who you don't want. Right? You know that.
Yep.
And there's no point in all dog and pony. You're going to strike that person. You got 6 of them. You got 6 strikes, and you know who you're going to get rid of. 2 or 3 of them already.
It amazes me sometimes how you'll have your 6 strikes that you think these are the people the plaintiff doesn't want, and then the defense will strike about 3 of them. Because it's not that they're biased one way or the other; they're just bad jurors. They're not people you'd want making a decision.
Oh yeah, and so I think the great lawyer, the great trial lawyer, is certainly have the forensic skill, can cross-examine and direct a witness, and so on and so forth. All of those, that's a prerequisite of being a good trial lawyer. But the great ones are the ones who can understand what the problems are and how to get around that problem, or have a strategic plan to get around the problem, and not wait until the problem comes up to see if I can solve it. Those are the really great ones.
Have you ever had any trials where lawyers were kept on the jury? You had lawyers who were jurors?
All the time.
Really?
All the time.
I don't think I would let that happen.
Oh my gosh. I just had a trial with a lawyer and a nurse. A medical trial. I've had trials with judges on the panel. Harold Melton was in here the other day. Of course, he didn't get selected, but
No.
but yes, it's amazing how lawyers are kept on jury panels all the time.
Do they make good jurors, or would you?
I think they do. I think
Yeah.
I think they do. I think they have a good understanding of the law. They have they really try to be unbiased, and I have not found lawyers to be problems on the jury.
My concern is leaving a lawyer on. All the non-lawyers will look to that one juror and say, "Oh, well, you're the expert. You decide. You tell us how to do it." And then you're trying a case to one person.
They do have a lot of influence.
Yeah.
And I think it also depends on the kind of discipline of practice too. Another thing that's amazing to me is people in the insurance adjusting business are kept on the jury.
Not on my juries.
Well,
Yeah.
Well, I don't.
I would never let that happen.
For example, I had a medical case where one of the jurors was this woman who had a very seasoned adjuster in that kind of world. And in asking her questions about, personal experience and family, and she recounted how this one medical provider had really, really fell down on the job, and she was so disappointed. And the family ended up with a huge loss, and there's litigation that was involved, and she pursued it, and she was dogged about it, and so on and so forth. So she was not presupposed that the defendant is wrong in the case. She's very willing to listen, and she was kept on that jury.
It's interesting.
Yeah, that is. I agree that you have to get into the life experiences of jurors to know. You can't just say, "Oh, you're an insurance adjuster. Forget it. You're off." I agree.
Yeah.
But I've had that come back to bite me once with an accountant, which another.
I'm never leaving
an accountant on, but the same situation. The accountant's sister had been a victim of medical malpractice. They'd filed suit, and he didn't think they had got enough money. And I'm like, oh, this guy might be okay.
Yeah.
Big mistake, but okay.
So I think the takeaway is we all have, I think the plaintiff's bar and the defense bar each has a sort of like a model of what jurors that they don't want. I think the idea of picking a jury is wrong. We don't pick a jury. We eliminate a jury. Okay, so everybody knows this is the type of jurors I just can't have. Everything else I can deal with.
Yeah.
Right? So each side has that. And I guess the art of jury selection is to figure out which one you say it's okay. I don't mind keeping them if I didn't have a choice.
Mm-hmm. Yeah. So I'm sitting here, in my study today, and they're waiting on the jury to come back in the Trump case. And one of the interesting things to me was they had closing arguments in that case that it was like 7 hours of closing argument, in that case. And I was telling somebody, in Georgia, unless it's a capital case, you only get an hour to close, even in a murder, well, not in a murder trial, but, it could be a rape case or something that would, give you life in prison. And I'm not a big fan of the long, drawn out closing argument. And I kind of think that people who watch legal shows on TV, they got to get closing argument in before they get to the next commercial. And I think they have a lot of impatience for that. But I'm curious as to what you think about length and openings and closings and that kind of thing.
I think a compelling opening is important. I think an opening that has enough facts, but leave a lot to be desired by the imagination, is the most effective. I'm going to prove this to you, and I want you to think about this. If this had happened, what would the end result be? Okay, that's sort of, I'm going to have Dr. So-and-so going to testify to so-and-so. Forget all that. All right? So you know what you're going to do with your case. So you want to give them enough to whet their appetite, to want them to say, God, can't wait to hear what's coming. Okay? And so I also think in most, at least on the plaintiff side, there's some hesitancy to ask for money. I don't understand that. It's like they go on and on and on. I'm sitting up there tapping my feet going, get to the number. there's just this sort of shyness about asking for compensation, the amount of compensation. I don't understand that. Now, the good ones, they would say, and I've seen done many different ways. Some would just throw out a number. Nowadays, money is like monopoly. Verdict has gotten huge. Folks don't seem to mind rolling out big dollars. Juries don't. I mean, also, I'm seeing on this case, in cases that there's a lot of defense verdicts too. People don't talk about that either. In DeKalb, I just had a case. I thought the plaintiff was going to get a $10, $12, $15 million verdict. That's my number. Came back with a D.
Mm.
All right.
That's
and
tough.
another car wreck case. I said, oh, okay, they're going to do this and do that. And I said, yeah, all right, 100, 150. Jury came back with $1 million. I almost fell out of my chair. But that's jury trials. It's a crapshoot. Some days you're the dog, and some days you're the tree.
Yeah, that's for sure.
Yeah, so you don't know, but I think in argument, I agree with Lester that we draw on to. I think jury loses focus on what you're saying after about 20 minutes.
Well, let me ask you this,
no
Judge.
preacher I know gets by with more than 20 minutes.
Yeah, that's true. But Judge, if a lawyer came to at the end of the trial, a lawyer said to you, Judge, I need 6 hours for a closing argument, what would your response be?
I said, well, have you read your rules? Okay, you get 2, the max. And if I were you, I wouldn't do more than 30 minutes.
Which is the rule in federal court. And they'll sometimes even make the defendants split it up, get 15 minutes each, so. Well,
I think the way I've done it is basically look at the lawyer and says, look, how much time do you all need? And I said, Judge, I'm going to need about 45 minutes. I said, is that the best you can do? He said, well, maybe 40, 45, an hour. I said, okay. So at 45 minutes, I'm going to give you a heads up. Okay. At an hour, I'm going to close you down. So I'm committing you to that. He said, okay. Then if you did that from the front end, then I think they tend to shorten rather than lengthen the argument.
Well, that's great. That's great advice. Judge, one thing I want to talk a little bit about before we're kind of nearing an hour, but I want to talk a little bit about because it is amazing to me is your public service and the creation of GAPABA, the Georgia Asian Pacific Bar Association. And I mentioned when I was introducing you that you and another fellow looked around to find 10 Asian lawyers. And now the group has 750 members in the bar, in that bar. And its top prize is the Judge Alvin T. Wong Pioneer Award. Wow. I mean, congratulations. I mean, that's amazing. You have an award named after you, which you should, in my opinion.
I'm still alive.
And you're still alive. And you won the Traditions of Excellence. I mean, it just goes on and on, but that's pretty awesome to have an award named after you.
Thank you.
Tell us a little bit about your service to the Asian Pacific Bar and what that means to you.
That is probably my most fulfilling achievement, if you will. Natsu Saito was then a associate at Troutman Sanders, now Troutman Peppers. She was writing airplane leases, and Paula Frederick, the bar counsel, our past bar counsel, called me up one day and said, I just come back from the APA. I met some folks in the National Asian Bar Association. They said, gee, don't you all have some Asian lawyers in Atlanta? You can start a chapter. Will you try? I said, well, sure, I'll try. So he said, do you know Natsu over here at Truman? I said, no. So Natsu and I got together and we took a bar directory. Back in those days, the bar directory was printed.
Right.
And said, let's meet for lunch. So we brought our bar directory, we sat down at lunch, and we circled everybody that sounded Asian. And we divided up the list, and we called them. And we got 13 people to start a chapter. Last night, we just had our 10th annual gala. So the association is now 31 years old. We just had our 10th annual gala last night at the aquarium. 600 people sold out.
Wow.
Oh,
it was unbelievable. I mean, judges, general counsel, just a ton of people. It was a great party. And so I think in 2014, maybe a little bit before, right around that time, Han Choi, if you knew him, he was a corporate lawyer, but great member of our organization. He's the one who decided that they would name the Judge Alvin T. Wong Pioneer Award. They didn't ask me, they just did it. And so I'm very flattered, very honored. And so every year I get up on stage and present the award. I don't have to say anything. I don't have to do anything. I'm just a pretty face handing them a plaque. And so that's great. It's a lot of fun. I really enjoyed it. The organization raises a lot of money, and we give away a lot of money to all of the community groups in immigration and housing, all the legal needs, education, all the underserved communities, healthcare, all of these groups. We fund a fellowship at Advancing Justice that does impact litigation on all these issues every year. So, it's good work. It's good to take care of your people.
Thank you so much for starting that. I think you're deservedly proud of what you've done and accomplished. And by the way, we'll put up to a link to the podcast, the GAPABA website, because they always take about 100 pictures at the gala. And I'm sure they did last night. So we'll see what you had on.
Oh my God. That party is just so much fun. Y'all need to come.
It looks like a lot of fun. I was looking at the pictures from last year at the gala. And I'm like, oh my gosh.
So the drink last night, the drink,
the signature cocktail.
The signature cocktail. They have a martini kind of margarita, kind of martini with lychee. If you don't know what lychee is, it's a Chinese fruit. Oh my God, that thing was great. I said,
it was a hit.
I said, I don't want it in a martini glass. Put it in a double and put some ice in it and give me a couple of those lychees, please. It was a wonderful party.
That sounds great.
Judge, I was going to say, we've also, one of the things we hadn't mentioned, we've now got Judge Wong as one of our state bar ABA delegates. And so been serving in the house with him and have really enjoyed that. And you're on several of the committees and whatnot with the ABA. And also I'm on the board of governors with his niece, who is a Georgia lawyer, lives in Connecticut now, but who has been so kind to me to show me the ropes simply because I'm friends with you, Judge.
Oh, thank you. You're very kind. Well, and I appreciate, if we don't talk about you enough, Lester, is your service to the bar. Been bar president and now still involved in the ABA. And both of you been, great contributor to our organization, to the practice of law. So thank you both of them very much. And especially for doing something like this for the general public.
Robin had to be president a couple of years after me to clean up the mess I made, when I came through. So
that's right. Judge, I'm wondering if you can tell us what your favorite part of being a judge is and what's the hardest part of being a judge.
My favorite part is to resolve disputes. civil or criminal. The hardest part of my job is to send somebody to jail. Putting them in prison, I don't do prison because I'm a misdemeanor judge, but putting them in jail. Sometimes you just have to. There's just no choice. I don't like doing that. My favorite part of the job with cases is resolving them. My favorite part of programs that I'm involved in is to help folks get back on their feet, be it addiction, employment, and so on. You know, in state court, in the misdemeanor world, we get a lot of young people or people with no really real criminal history, and they just get off the track a little bit. So, you know, I enjoy helping ones that won't help, and enjoy resolving disputes.
I've often heard that the state court is the place where most citizens would have any interaction with a court system, with the judicial system. It's not going to be superior court. It's going to be state court. And I can only imagine how many Georgia citizens have appeared in front of you. It would be tens of thousands, I assume.
Well, I don't know about tens of thousands, but I've seen a lot of folks. You know, the funny thing is that I see a lot of my defendants out in the square in Decatur that speaks to me and say, "Hey, Judge."
And my guess is some of them thank you.
Well, some, not many.
Some. Well, Judge, we are cognizant of your schedule and we appreciate your time today. We always ask our guests this final question, and that is, what is your definition of justice? How do you define justice?
I define justice as fairness, opportunity to be heard, and be treated equally. Okay, you got to be fair. You got to have your say, and whatever the rule or the law is, that you're treated like you should be. Okay, not because of your status, not because of your race, not because of your financial wherewithal. That I walk into a court system that I'm going to have an even shake. I mean, I think that's our democracy, right? I mean, that's the way we are supposed to be in this country. We don't always meet the benchmark, but that's the way we're supposed to be. So I think my role is to hopefully keep it on track.
Yeah, make sure that happens.
Make sure that happens.
Awesome. Well, you've been doing it now for how many years?
Oh my God, don't ask me that.
Okay, never mind.
I'm in my 25th year as a judge.
Wow. Awesome. And
yes. And folks ask me and say, "Oh, are you going to quit? Are you going to, the time to go?" I said, "Well, no, Jeannie Lynn's not going to let me come home for lunch yet."
Oh, that's a good one. Well, Judge, we just appreciate your time so much. Thank you for being with us. Again, we've been talking with the Honorable Alvin T. Wong, Judge of the DeKalb County State Court. And you can learn more about Judge Wong and the DeKalb County State Court at DeKalbStateCourt.net. Judge, thank you again. It's been a pleasure.
Thank you, Robin. Thank you, Lester. Keep up the good work. I appreciate both of you very much, and it's an honor to be with you today.
So great guest, Al Wong today, Judge of the State Court of DeKalb County. And now, Robin, it's where we usually talk about some item in the news that we think our listeners may enjoy hearing about. And I'm gonna go first. And I have a truly viral one today. It's from the CBS News, dated May 29th, 2004, but you can Google it and you can find it anywhere. You can go on Twitter, Instagram, Facebook, but it's a story entitled "Video Shows Man with Suspended License Zoom into Michigan Court While Driving." And the story is that a Michigan man appeared virtually in the county court hearing and was ordered by the judge to turn himself in after the camera showed him actively driving while under a suspended license. And it happened in a May 15th hearing. The video is, I encourage people to watch it. Video from the hearing shows the moment he joined the hearing, he was behind the wheel of a car in motion. And by the way, Michigan has a law that prohibits the use of cell phones and other electronic devices while driving. And the judge says, are you stationary? And he goes, actually, I'm pulling into my doctor's office right now. So just give me a second. I'm parking. And then the judge just kind of says, wow, so maybe I don't understand something. This is a driving while suspended license case. And he was just driving. And the defendant looked at the camera and came to the, as CBS describes it, the grim realization dawning on his face. And so the judge says, I don't even know why he would do that. He revoked his bond and ordered him to appear in at jail by 6 p.m. that day. So, you know, when you do criminal defense work, you always have at least one client that's like this. And I felt for the lawyer, who I think was a public defender in this case, but it's sort of amazing that some people don't ever learn their lesson.
What an idiot. And, you know, as a public defender, a lawyer for that person, would you even need to advise them, hey, don't be on the phone driving when we're in front of the judge on your suspended driver's license? Do you need to counsel that person that? I mean, that's mind-boggling.
Yeah, it's pretty stupid. You know, it's pretty stupid.
I tell you, when back in COVID, when we were doing everything by Zoom, I would often watch preliminary hearings and things like that. And I saw things, the judges just had to put up with it. But, you know, I saw one defendant sitting at a bar in some other country, like Mexico or something, having a drink at a hearing. I was flabbergasted. I remember it was Judge Besson, and she handled it very well. I wouldn't have handled it so well if I'd been the judge, but that's probably why I'm not a judge. Well, I have an interesting one because, Lester, we can now rest easy tonight because that long debated legal question that so many have wrestled with and worried about has finally been answered. And that question is, are tacos and burritos sandwiches? And a judge in Fort Wayne, Indiana, ruled yes, that tacos and burritos are sandwiches. Allen County Superior Court Judge Craig Bobe, or Bobe, I don't know how to pronounce his name, issued a ruling that tacos and burritos are Mexican-style sandwiches. He made the decision in a case reviewing whether a restaurant, Famous Taco, could open a new location at a Fort Wayne shopping center. Turns out there was a zoning policy for that property that prohibited fast food, but allowed exceptions for restaurants whose primary business is to sell made-to-order or Subway-style sandwiches. And apparently some folks who lived around the shopping center had complained. They thought allowing Famous Taco into the shopping center would wreak havoc on their lifestyle, bring too many cars in the area, that sort of thing. And they sued, and the judge issued his ruling that no, tacos and burritos are sandwiches, so they fall within the zoning rule. They're allowed. And he hypothetically said other restaurants that serve made-to-order items, including Greek gyros, Indian non-wraps, or Vietnamese banh mi, would also be allowed as sandwiches. So there you have it. It's been decided, at least in Indiana, that tacos are sandwiches. And I think we can have a good night's sleep over that issue now.
After enjoying a taco sandwich, you know, I suppose that's
Yes.
there's never any shortage interesting things that make their way into the courts of
Right.
of the state of Georgia or other
Critical issues that have to be decided by a court.
Yeah.
Well, that does
sounds
it
like
for
there
us.
may have been an element of this is a petty objection involved in that too.
Yeah, definitely. Kind of ridiculous, but that does happen. All right. Lester, I don't have anything else. Do you?
I don't either.
Oh,
And so,
actually, one last item. I wanted to let our listeners know
sure.
that when we had Ken McCracken Poston Jr. on, who's written the book Zenith Man, there was an article in the ABA Journal about his book this week. So the article begins. The title is "Lawyer's True Crime Book Explores How He Defended a Neurodivergent Client Charged with Murder," and it's all about Ken Poston's book Zenith Man, and we've had him on as a guest. And I just wanted to I sent that to Ken to let him know. I'm sure he knows about it, but
Yeah,
I was glad to see that in the ABA Journal.
That's great. That's
Yeah.
great. I'm wondering, the ABA Journal used the term neurodivergent. I wonder if at the time of that trial, because Ken talked about his client's mental conditions, but I wonder if anybody in Dade County knew what neurodivergent meant at that time.
I doubt that word had ever been uttered in Dade County at that point, but it stories like that allow people to understand why some folks are different, and I think it's a great thing.
Well,
all right.
Wraps up our program today, and until next time, we'll see you in court.
See you in court.
You've been listening to the See You in Court podcast, brought to you by the Georgia Civil Justice Foundation. Remember, justice is a shared journey, and your engagement makes all the difference. For further insight and resources, visit our website at www.seeyouincourtpodcast.org. Subscribe to our YouTube channel at See You in Court Podcast for additional content. And don't forget to engage with our community on Facebook.com/seeyouincourtpodcast. Special thanks to our producer, Philip Hoover. I'm Fred Smith, Executive Director of the Georgia Civil Justice Foundation. You may learn more about the foundation at www.fairplay.org. Until next time, we'll see you in court.